Section 3, page 19, applicable laws and department and FBI policies. This section begins by summarizing some of the principles of federal prosecution, which govern all federal prosecutions. Next, this section describes the laws and policies that we consider in the course of our investigation. These include the requirements that apply to the FBI's assessment and the investigations of counterintelligence matters, most of which are found in guidelines promulgated by the Attorney General and the FBI policies, and the legal standards for conducting electronic surveillance under FISA. This section concludes by describing the principal statutes that we use to evaluate possible criminal conduct for prosecution. It lists a bunch of statutes. Section A, Principles of Federal Prosecution. In deciding whether to exercise prosecutorial authority with respect to the statutes discussed below, the office has been guided by the principles of federal prosecution set forth in the Justice Manual. Those principles include: 1. Determination to prosecute. A determination to prosecute represents a policy judgment that the fundamental interests of society require the application of federal criminal law to a particular set of circumstances. The attorney for the government should commence or recommend federal prosecution if he/she believes that the person's conduct constitutes a federal offense and that the admissible evidence will probably be sufficient to obtain and sustain a conviction, unless the prosecution would serve no substantial federal interests, the person is subject to effective prosecution in another jurisdiction, or there exists an adequate non-criminal alternative to prosecution. 2. Substantial federal interest. Determining whether a prosecution would serve a substantial federal interest, the attorney for the government should weigh all relevant considerations, including federal law enforcement priorities, including any federal law enforcement initiative or operations aimed at accomplishing those priorities, the nature and seriousness of the offense, the deterrent effect of prosecution. Page 20. The person's culpability in connection with the offense, the person's history with respect to criminal activity, the person's willingness to cooperate in the investigation or prosecution of others, the person's personal circumstances, the interests of any victims, and the probable sentence or other consequences if the person is convicted. 3. Most serious, readily provable offense. During our investigation, the Justice Manual provided that once the decision to prosecute has been made, the attorney for the government should charge and pursue the most serious, readily provable offenses. By definition, the most serious offenses are those that carry the most substantial guideline sentence, including mandatory minimum sentences. 4. Unpopularity. Where the law and the facts create a sound prosecutable case, the likelihood of an acquittal due to unpopularity of some aspects of the prosecution or because of the overwhelming popularity of the defendant or his/her cause is not a factor prohibiting prosecution. This provision from the Justice Manual is quoted more fully in Section 1. 5. Interests of uncharged parties. In all public filings and proceedings, federal prosecutors should remain sensitive to the privacy and reputation interests of uncharged third parties. In the context of public plea and sentencing proceedings, this means that in the absence of some significant justification, it is not appropriate to identify either by name or unnecessarily specific description or cause a defendant to identify a third-party wrongdoer unless that party has been officially charged with the misconduct at issue. As a series of cases makes clear, there is ordinarily no legitimate governmental interest served by the government's public allegation of wrongdoing by an uncharged party, and this is true regardless of what criminal charges may be contemplated by the Assistant United States Attorney against the third party for the future. Courts have applied this reasoning to preclude the public identification of unindicted third-party wrongdoers in plea hearings, sentencing memoranda, and other government pleadings. Page 21. In a similar vein, the Deputy Attorney General Rosenstein stated that we do not hold press conferences to release derogatory information about the subject of a declined criminal investigation. He went on to say that the derogatory information sometimes is disclosed in the course of criminal investigations and prosecutions, but we never release it gratuitously. B. The FBI's assessment and investigation of counterintelligence matters. This subsection describes the requirements that apply to the FBI's assessment and investigations of counterintelligence matters. The AGG-DOM gives the FBI a broad mandate to detect, obtain information about, and prevent and protect against federal crimes and threats to the national security. These crimes and threats include espionage and other intelligence activities and foreign computer intrusions. The AGG-DOM provides that these guidelines do not authorize investigating or collecting or maintaining information on United States persons solely for the purpose of monitoring activities protected by the First Amendment or the lawful exercise of others' rights secured by the Constitution or laws of the United States. The requirements of the AGG-DOM are implemented and expanded upon in FBI policy. In its investigative activities, the FBI is to use less intrusive investigative techniques where feasible, and investigative activity is broken down into various levels. There are also requirements and separate guidelines approved by the Attorney General governing the FBI's use of confidential human resources, CHSs, finally. In 2020, the department imposed additional requirements for politically sensitive assessments and investigations for applications under FISA. 9 of the 10 persons named in the indictment were active in the Vietnam Veterans Against the War or anti-war group. The naming of appellants, this is one of those sidebars. I'm not going to finish reading this. Skip to page 22. Number 1, use of least intrusive means. The President has directed that the intelligence community shall use the least intrusive collection techniques feasible within the United States as directed against United States persons abroad. The intelligence community includes the intelligence elements of the FBI. The AGG-DOM implements this provision and observes that the conduct of investigations and other activities may present choices between the use of different investigative methods that are each operationally sound and effective, but that are more or less intrusive, considering such factors as the effect on the privacy and civil liberties of individuals and potential damage to reputation. There is additional discussion of requirements for a sensitive investigative matter, or SIM, principally in the DIOG. One category of SIM is a matter of involving a political candidate or a domestic political organization or individual prominent in such an organization. The definition of a SIM, which remember is sensitive investigative matter, also includes any other matter which, in the judgment of the official authorizing an investigation, should be brought to the attention of FBI headquarters and other Department of Justice officials. It goes on to explain. In a SIM, particular care should be taken when considering whether the planned course of action is the least intrusive method of if reasonable, based on the circumstances of the investigation. 23. More generally, when First Amendment rights are at stake, the choice and use of investigative methods should be focused in a manner that minimize potential infringement of those rights. If the threat is remote, the individual's involvement is speculative, and the probability of obtaining probative information is low. Intrusive methods may not be justified, and in fact, they may do more harm than good. The DIOG says that the FBI will apply best judgment to the circumstances at hand to select the most appropriate investigative means to achieve the investigative goal. At the same time, it shall not hesitate to use any lawful method, even if intrusive, where the degree of intrusiveness is warranted in light of the seriousness of the criminal or national security threat. The factors that may support the use of more intrusive collection techniques include operational security. 2. Levels of investigation. One significant way that the AGG-DOM and the DIOG implement the least intrusive means requirement is by describing 4 different levels of activity. The first is activity that the FBI may conduct without any formal opening or authorization process and is referred to as activities authorized prior to opening an assessment. The other, more formalized levels of activity are assessment, preliminary investigation, and full investigation. As the level increases, the FBI may use a broader range of techniques. A. Activity authorized before opening an assessment. The DIOG states that when initially processing a complaint, observation, or information, the FBI employee may take limited steps to evaluate the information. These include looking at government records and at commercially and publicly available information. The employee may also conduct a voluntary clarifying interview of the complainant or the person who initially furnished the information for the sole purpose of eliminating confusion in the original allegation or information provided. The DIOG explains that these activities may allow the FBI employee to resolve a matter without the need to conduct new investigative activities. New investigative activity requires the opening of an assessment or predicated investigation. Page 24. B. Assessment. The FBI may open an assessment if it has an authorized purpose and a clearly defined objective. No particular factual predication is required for the basis of opening an assessment. Cannot be arbitrarily or groundless speculation. In addition to the techniques that are authorized without opening an assessment, in an assessment, the FBI may recruit and use CHS's conduct physical surveillance in 72-hour increments and obtain some grand jury subpoenas. An FBI employee should be able to explain the reason for the use of particular investigative methods. C. Preliminary investigation. The factual predicate required to open a preliminary investigation is information or an allegation that a federal crime or a threat to the national security may be occurring. Authorized investigative methods include undercover operations, trash covers, consensual monitoring, PIN registers, national security letters, and polygraphs. The FBI may also conduct physical searches and use monitoring devices that do not require judicial authorization. A preliminary investigation is to last a relatively short time and lead either to closure or a full investigation. D. Full investigation. The standard for opening a full investigation is an articulable factual basis for the investigation that reasonably indicates that a. An activity constituting a federal crime or a threat to the national security is or may be occurring, and the investigation may obtain information relating to the activity. The DIOG gives as examples of sufficient predication to open a full investigation. Example 1. Corroborated information from an intelligence agency stating that an individual is a member of a terrorist group. Example number 2. An analyst discovers on a blog a threat to a specific home builder and additional information connecting the blogger to a known terrorist group. The FBI may use all lawful methods in a full investigation, including court-authorized electronic surveillance and physical searches. The confidential human source guidelines is number 3. In addition to the AGG-DOM, the Attorney General has approved separate guidelines governing the FBI's use of human sources. The guidelines in place at the time of Crossfire, page 25, hurricane, required the validation of a CHS when the person was opened as a source. Validation included documenting the person's criminal record and motivation providing information. Because a source's reliability can change, the guidelines directed the FBI to review each CHS's file at least annually and ensure that all available information that might materially alter a prior validation assessment is promptly reported to a supervisor and documented. The guidelines also require that an FBI agent instruct the CHS. Because the instructions are important, another agent or official was to be present as a witness. The agent was to direct the CHS to provide truthful information and to abide by the instructions of the FBI. If the FBI compensated the CHS was liable for any taxes that may be owed. The guidelines explain that the content and meaning of each of the instructions must be clearly conveyed to the CHS. Immediately afterward, the agent shall require that CHS to acknowledge his or her receipt and understanding of the instructions. Page 26. The guidelines did not include an explicit requirement to document whether the person has previously been a source of intelligence or a law enforcement agency. Moreover, the FBI was not required to seek or obtain the approval of the department before using sources to record conversations and obtain information not only from targets of its investigation in Crossfire Hurricane, such as Page and Papadopoulos, but also from a senior campaign official to whom its sources had access. 4. Analytic integrity. The FBI's Counterintelligence Division is an operational component, whereas a separate Directorate of Intelligence provides analytic support. The Counterintelligence Division's policy guidance says that effective operations are based on integration of personnel from the two entities who work toward common goals. Division personnel must cultivate and develop relationships with Directorate of Intelligence elements in order to maximize operational performance. Case agents should rely on the Directorate of Intelligence for strategic and tactical guidance on targeting priorities, the generation of source debriefing packages, and evaluation of source reporting, preparation of various raw intelligence dissemination products, and the identification of intelligence gaps. For the intelligence community as a whole, Congress has directed the Director of National Intelligence, DNI, to assign a person or entity to be responsible for ensuring that finished intelligence products are timely, objective, independent of political considerations, based upon all sources of available intelligence, and employ the standards of proper analytic tradecraft. The intelligence community's analytic standards say that analysts must perform their functions with objectivity and with awareness of their own assumptions and reasoning. They are to employ reasoning techniques and practical mechanisms that reveal and mitigate bias. Moreover, all IC analytic products should be independent of political consideration and not be distorted by the advocacy of a particular agenda or policy viewpoint. Responding to a congressional inquiry, the intelligence community's analytic ombudsman documented a few incidents from 2020 where individuals or groups of individuals, 27, took willful action that had the effect of politicizing intelligence, hindering objective analysis, or injecting bias into the intelligence process. The Ombudsman assessment mentioned the reluctance of China analysts to have their analysis brought forward because they tended to disagree with the administration's policies. On the other hand, Russia analysts were frustrated because management was slowing down or not wanting to take their analysis to customers, claiming that it was not well received. The assessment also has a section entitled Historical Context. It discusses the politicization of intelligence about Iraq in 2003, but it does not mention Crossfire Hurricane or the Carter Page FISA. The assessment paraphrases former intelligence official Neil Wiley. Intelligence is the only great function of state that does not come to top decision makers with an agenda. The purpose of intelligence is to provide objective, unbiased, and policy-neutral assessments. We are perhaps most important to decision makers when we bring to them the bad news. This sometimes demands moral courage to carry out. Other institutions are inherently political and are much less likely to bring bad news. If we lose that objectivity, or even are perceived to have lost it, we have endangered the entire reason for us to exist. 5. Recently upgraded protections. A. Investigative activities. The Sensitive Investigations Memorandum, promulgated by Attorney General in 2020, imposes additional approval requirements for politically sensitive activities. If the FBI takes exploratory investigative steps relating to a presidential candidate, a senior staff member, or an advisor, it must give prompt written notice to the appropriate Assistant Attorney General and U.S. Attorney. The Attorney General explained that this includes any person who has been publicly announced by a campaign as a staffer or member of an official campaign advisory committee or group. The same notice requirement applies if the FBI opens an assessment of such person. If the FBI opens either a preliminary or full investigation of a person, then, page 28, notice to the department is not enough. The Attorney General must approve the opening of the investigation. The memorandum also directs department components to review their existing policies governing notification, consultation, and/or approval of politically sensitive investigations, provide a summary of those policies, and recommend any necessary changes or updates. The department to study, after the 2020 elections, its experiences and consider whether changes to the requirements in the memorandum are necessary. The Attorney General recently reaffirmed the need to adhere to the requirements of the Sensitive Investigations Memorandum that govern the opening of criminal and counterintelligence investigations by the department related to politically sensitive individuals and entities. B. CHS Guidelines and Policy. In 2020, the following various OIG reviews, the FBI undertook a comprehensive review of the 2006 CHS guidelines to ensure that the FBI's source validation process was wholly refocused, revised, and improved across the FBI. The 2020 CHS guidelines thus provide additional direction to the FBI in the handling of human sources. They require information about whether the CHS is reasonably believed to be a current or former subject or target of an FBI investigation. There is also a new requirement for information about a source's reporting relationship with other government agencies. At the time when the Attorney General approved the guidelines, he also directed that, pending further guidance, he or the Deputy Attorney General must approve any use of a CHS to target a federally elected official or political campaign for the purposes of investigating political or campaign activities. Page 29. The FBI's Confidential Human Source Policy Guide also includes new or strengthened requirements and implements portions of the Sensitive Investigations Memorandum. Its requirements include identifying the specific source-related activities in which FBI intelligence analysts and other non-agent personnel may engage. For example, an intelligence analyst may only contact a CHS or a potential CHS in the presence of a case agent. An analyst may only accompany an agent to a debriefing of a CHS with supervisory approval. Requiring information about all likely motivations the CHS would have providing information, enhancing the requirements for source validation reviews, requiring detailed information and additional approvals in a request to reopen a CHS who was previously closed for cause, either by the FBI or another agency. Finally, the CHS Policy Guide requires a CHS to be treated as sensitive and thus subject to more controls based on either the position the source holds or the position held by someone the source is reporting on. So, for example, even though a CHS may not hold a position in a campaign, if the source is reporting on such a person, he/she would still be treated as sensitive. Post-Crossfire Hurricane, the guide now provides this example. A CHS with indirect access to a U.S. presidential campaign is tasked to report on campaign activities involving possible cooperation with foreign entities to influence the outcome of a U.S. presidential election. The CHS had only indirect access, but his or her affiliation nevertheless enabled the CHS to be tasked to collect information on the campaign. C. Defensive briefings. The OIG's reviews of Crossfire Hurricane discusses defensive briefings for those who may be targets of nefarious activities by foreign powers and specifically at the time of the, page 30, investigation. The possibility of conducting a defensive briefing for the Trump campaign on Russian activities. The review says that we did not identify any department or FBI policy that applied to this decision and therefore determined that the decision whether to conduct defensive briefings in lieu of opening an investigation or at any time during an investigation was a judgment call that is left to the discretion of FBI officials. It went on to suggest that it would be desirable to give senior department leadership the opportunity to consult with the FBI about whether to conduct a defensive briefing in a circumstance such as this one. The department and the FBI have taken steps to address this issue. First, the Attorney General has instructed the FBI Director to promulgate procedures concerning defensive briefings. The purpose of this requirement is to address concerns that U.S. persons may become unwitting participants in an effort by a foreign power to influence an election or the policy or conduct of the government. Second, the FBI has established a Foreign Influence Defensive Briefing Board, FIDBB. The FBI is continuing its newly implemented review process for malign foreign influence defense briefings, and in particular briefings to legislative and executive branch officials. This will encompass actions taken after receipt of specific threat information that identifies malign foreign influence operations, that is, foreign operations that are subversive, undeclared, coercive, or criminal, including convening the FIDBB to evaluate whether and how to provide defensive briefings to affected parties. To determine whether notification is warranted and appropriate in each case, the FIDBB uses consistent, standardized criteria guided by principles that include, for example, the protection of sources and methods and the integrity and independence of ongoing criminal investigations and prosecutions. C. The Foreign Intelligence Surveillance Act, FISA. FISA permits the government to seek authority from the FISC to use a range of investigative techniques for the installation and use of pen register and trap and trace devices, which are relatively unintrusive. FISA requires that the information likely to be obtained is relevant to an FBI investigation. For electronic surveillance, which is among the most intrusive technique available to the FBI, the requirements are more extensive. We describe below some of the findings required by the statute, FISA's First Amendment proviso, and the certification by a high-ranking executive branch official. This subsection concludes by summarizing some of the executive branch's requirements for FISA applications, many of which have been added in recent years. Number 1, required findings. FISA requires the government submit an application to the FISC describing the target of the surveillance, the techniques that will be used, and other matters. An FBI agent or other federal official swears to the truth of the facts in the application. The FISC may authorize electronic surveillance if there is probable cause to believe that the target of the surveillance is an agent of foreign power. For a U.S. person, there are at least two additional related requirements. First, as the House Intelligence Committee's 1978 report on FISA explains, a matter of principle, no United States citizen should be targeted for electronic surveillance, absent some showing that he at least may violate the laws of our society. Second, the person must be knowingly engaged in the specified conduct. Thus, a U.S. person may be an agent of a foreign power if the person is knowingly engaging in clandestine intelligence gathering activities on behalf of a foreign power, or knowingly helping another person in such activities, provided that the activities involved may involve a violation of U.S. criminal law. The House report goes on to explain how foreign powers may engage both in intelligence gathering and other nefarious intelligence activities. Page 32. Not only do foreign powers engage in spying in the United States to obtain information, they also engage in activities which are intended to harm the nation's security by affecting the course of our government, the course of public opinion, or the activities of individuals. Such activities may include political action, recruiting, bribery, or influencing of public officials to act in favor of the foreign power, disguised propaganda, including the planting of false or misleading articles or stories, and harassment, intimidation, or even assassination of individuals who oppose the foreign power. Such activity can undermine our democratic institutions as well as directly threaten the peace and safety of our citizens. Consistent with this discussion, a U.S. person engaged in political action or other non-intelligence gathering activity may also fall within the definition of an agent of foreign power. This is the case if a person knowingly aids or abets or conspires with any person who, pursuant to the direction of an intelligence service or network of a foreign power, knowingly engages in or clandestine intelligence activities for or on behalf of such foreign power, which activities involve or are about to involve a violation of the criminal statutes of the United States. Because these other activities may come closer to activity protected by the First Amendment, the required level of criminal involvement is higher in this definition. The House report explains that the activities engaged in must presently involve or be about to involve a violation of federal criminal law. Again, this is a higher standard than is found in other definitions, where the activities may involve a violation of law. In this area, where there is close line between protected First Amendment activity and the activity given rise to surveillance, it is most important that where surveillance does occur, the activity be such that it involves or is about to involve a violation of a federal criminal statute. The House report also discusses the aiding or abetting provision at length and says that FISA allows surveillance of any person, including a U.S. person, who knowingly aids or abets any person in the conduct of activities described. The knowledge required is applicable to both the status of the person being aided by the proposed subject of the surveillance and the nature and activity of being promoted. This standard requires the government to establish probable cause that their respective target knows both that the person whom he is conspiring or whom he is aiding or abetting is engaged in the described activities as an agent of, page 33, a foreign power, and that his own conduct is assisting or furthering such activities. The report goes on to explain how the earlier surveillance of Martin Luther King, which was justified based on his association with members of the Communist Party, would not meet the standard. An illustration of the knowing requirement is provided by the case of Dr. Martin Luther King. Dr. King is subject to electronic surveillance on national security grounds when he continued to associate with two advisors whom the government had apprised him were suspected of being American Communist Party members and by implication agents of a foreign power. Dr. King's mere continued association and consultation with those advisors, despite the government's warnings, would clearly not have been a sufficient basis under the bill to target Dr. King as the subject of electronic surveillance. Indeed, if there had been probable cause to believe that the advisors alleged to be communists were engaged in criminal clandestine intelligence activity for a foreign power within the meaning of this section, and even if there were probable cause to believe Dr. King was aware they were acting for a foreign power, it would It would also have been necessary under this bill to establish probable cause that Dr. King was knowingly engaging in furthering his advisor's criminal and clandestine intelligence activities. Absent one or more of these required showings, Dr. King could not have been found to be one who knowingly aided or abets a foreign agent. As noted above, however, the knowing requirement can be satisfied by circumstantial evidence, and there is no requirement for the government to disprove lack of knowledge where the circumstances were such that a reasonable man would know what he was doing. The King excerpt underscores the need for the target to be knowingly furthering the criminal clandestine intelligence activities of those whom he is aiding, but it also explains that such knowledge may be inferred.